go to your mom's house, and at the age that you're at right now, you go to your mom's house and you tell her, hey, do this and do that and do this and do that. She ain't gonna listen to you because you came into her house. So if you come to her house, she's gonna tell you what to do. So by making them custodians, they're dealing with your property, so they're in your house. So the only way that you can make them do what they're supposed to do is by making them custodians. Because they have you in a trustee relationship while they playing the grantor.
No, they making him
quasi trustee. Absolutely.
You surety and
liable. So whatever they bring you
with, crossover taxable liability. Every court case is a tax. So what they're doing is making you liable. That's why they can put you in jail. That's why they can take your body because you're a surety and make you quasi-trustee and surety. Like he's saying, and put you in jail. So what you have to do is put yourself in the right position inside there and make them custodians and make yourself the top dog in the case.
And then other things, since they made you liable, you make them liable. But
yeah, you have to make them liable.
The script on it.
Okay, the next person says, yeah, go ahead. The next person stands up is Sanchez.
This has come to my attention that there's a court case with my name on it. I had no idea that it even existed. I was looking for some documents in the county record and I saw a court order. And in the court order, it was pertaining to a lien that I had on a property. And they never noticed me. So when I went into the court records to read about what happened, they had got an order from the judge in the Supreme Court on an international lien. And the judge made a decision that it went into default for non-response. So I didn't know what to do. I thought that I was transferring it and put it in my trust, but when I realized that when I actually read the whole thing, that it had already been decided on last month, the 30-day window is closed. So I don't know what to do.
What type of case is it? What is it that you done?
I can't do all this. I gotta get this room ready.
An international UCC lien. A lien.
So a lien on a property?
Yes.
So when you say a lien on a property, did you have possession? Hold on.
No, before she does that, I want you to
let me I just want to ask a question. So you said on a property, did you have possession of this property? Were you entitled to this property, or was you trying to?
I already had possession of the lien for a few years. I didn't know what to do, so I started studying, and then I landed here. Started to find out as much information as I could to be able to secure it. Just when I got to the point to figure out how to transfer it and put it in trust, is when I went researching, and I found that it had a court order on it based on a default, and it basically has been overturned by a lower court that had no jurisdiction. So I feel like they stole my security.
How did you obtain the property? No, that's what I'm asking. How did you obtain the property? Did you go through a mortgage? How did you obtain the property?
No. I owned it. I lived in a co-op unit, and I owned it. And I put the money in a court action.
So the property you owned it prior. How did you become the owner of that property? That's what I'm asking.
I brought and paid for it.
Say that again.
I brought it and I paid for it.
Oh, you bought it. Okay. Gotcha. So you have an interest in that property.
Son Kids, give me 1 second, Dayon. Hey, Son Kids, did you ask yourself the instrument that they have in the court case right now? Did you actually go down there and get a certified copy yourself?
That's what I wanted to do on Friday, and that's when I found the date and the deadline and the point of entry on it was a month ago. So no, I didn't get to that part yet, but
You still need to do it. Remember that.
Monday,
Could I speak just 1 second?
yes.
What I wanted to say is, it's a default judgment, correct?
It is.
A default judgment means that you will not serve. So
Yes.
you can always go back and get rid of the default judgment for lack of service, lack of due process.
Yeah, they never serve you properly. So yes, lack of due process.
Right, so you can always go back and you can amend that. So what you have to do first and foremost is go get that order, get a certified copy. And then from there, you're gonna have to take certain steps to, let me ask you a question. Are you still in the house?
No, this is years old, the lien is, and I had moved away from it, but I still have.
Well, what you probably want to do now, because you're not in the house, not to the law possession here.
I didn't hear it again, please.
9/10 of the law is possession here. So probably what you want to do is go get your entry. So since they did a default judgment, you probably get paid 10 times the amount, or whatever the judgment was. So you want to go and get that judgment sheet, and then you probably can have that amount sent to you. And let's say if the house was 100, you can have 1 million sent to you because of the contract. So you can just go get the interest since you're not in it anymore, or you can fight to get it back. It's up to you how you want to roll. But probably the easiest thing to do, because the court is 6 weeks, and Lucky understands the process with that. All you have to do is go get that judgment, and then you put a 1099-A and a 1099-B with it, and then have them send that to you because they did a default judgment, and you are the grantor, trustor, and trustee. And so then you just check that and send it to the IRS, and they should send you 10 times the amount U.S. currency, so you can take care of that. Lucky specializes in that, so you probably want to talk to Luck. But based on the law, you're sitting on 10 times the amount of whatever the judgment is.
So the judgment that you're speaking about is the judgment on the default, or because on the lien itself is valued at.
All it is a piece of paper. They said you defaulted, and so they put that on your name. You didn't know anything about it. Once you take it, certified copy accepted, place it on, then put yourself as the one who really controlled A and a B, then they will actually send you that money. So that's why I was trying to tell you, talk to Lucky, because Lucky specializes in that.
Thank you.
He's probably the best on the phone.
Thank you.
I'm gonna tap to stop speaking.
Okay. The next person with their hand up is Rachel.
My question was, does this process Big D was talking about work with people who's not in foreclosure?
It works on everything. That's why I said an indictment is a true bill. A summons is a true bill. It's the first document in court. It doesn't matter what you're in. All you're doing is, and Lucky and them and all them spoke of it, is you're doing your acceptance, because without acceptance, you can't perfect it. And once you perfect it, you take control of it. And once you take control of it, then you can do what you want with it.
Oh, what summons would I have if I'm not in default or in a foreclosure?
When you had a court case, they sent you something first. Either you got an indictment for a criminal case, or you got a summons for a civil case. It's only two things. A traffic ticket, that's the first thing they send. That's traffic court.
Which is still a summons. That's the same thing.
Summons. They set you up, and then so you go with the first document that was done in your traffic thing, and bam, there you go. So because remember, all that ticket is telling you to come to the court on a certain day, ain't it?
Oh, so what I was saying is I'm trying to do the process with the mortgage, but I'm not in the foreclosure.
Okay, so what you doing with that? Then you gotta have correspondence. That's what I thought. Then you gotta have correspondence with and they was telling you how to talk to the actual. You remember you heard the ladies before?
Jessica was talking about it. I'm not sure if he was on here. She might
I
go back over it.
late, but I do remember saying correspond with the trustee.
Well, see, I wasn't on here for that, so she probably gave you exactly who you contact if it's not in the court case. If it's not in the court case, then all you're doing is contacting the party that you're dealing with. And then you
can remember you always can start up a court case too if you need to do that.
But she don't have to. She don't need to start a court case update if she because they're gonna send her a bill or they're gonna send her some correspondence. She's gonna accept that correspondence the same way that you accept the court case. They're gonna say, like say for instance, they're gonna put on your principal and what your payment is. So when they send you that sheet, you're gonna accept that piece of sheet with your principal on it and your payment. And then you're gonna say this is and shall be negotiable. And then you're gonna pay everything that they gave you. But they just sent you that correspondence is nothing but money, something gonna turn into money. And then you're gonna do what the girls and all them was saying, and then you pay that bill because it was already paid at closing. So what they're doing is making you pay 2 to 3 times.
Can I speak?
Yeah, so go back and listen to the girl because I came in on the one who said she's done something and it's worked every time.
It's not, that's me, it's Jessica. But yeah, I am.
So go back and see exactly because all she did is place them on notice against what law with her. And if you add the acceptance in, they know they can't move because they don't hold it anymore.
Yeah, she's gonna have to do if the person is not in foreclosure. I would say stay in honor, no matter what you do, no matter what you hear on this, no matter what you hear on Clubhouse. Stay in honor with your note because I think the most important thing that most everybody is, we jumping around to all these codes and do this, do that. The bottom line, you gotta if you want to stick with how commerce works, everybody did a contract. You have you have the right to contract with whoever you want, whenever you want, to put your property tax. So that's what, if you look at, everybody got to go back and really look at their closing documents because, like I said in the beginning, you can rescind, you can do all that stuff. We've been fighting mortgages since 2009, like when it was a lot easier than it is now. Yes. But all of this, let me send this, let me send that. Number one, you're not sending it to the right people. That's the problem. And you're not dealing with the right people, and you're not dealing with it with the right perspective. So the bottom line is you signed a contract. Contracts are legal, binding, and enforcing. So even though we know what they did at closing with the strong man, all this, we can talk about it all day till you're blue in the face. Until you attack that contract appropriately, you're gonna lose. Because the only thing the Georgia judge is gonna do is enforce the contract. Now, can you go back and prove fraud? Absolutely. You can go back and prove fraud once the contract has been severed. So if they have you in court under performance on the contract, then you're gonna have to either negotiate that contract, renegotiate that contract, and that's usually what happens when people go back and do do the mortgage or what you call it, refinance, something like that, or get the mortgage company to actually extinguish the mortgage. But you got to do that through your contract that you initially did. So there's another procedure that you can do. The young lady that has the house, you want to get rid of your house, you can do in every state, and I'm going by, this one is for District of Columbia, but I like Georgia. Let me go to Georgia. Any debt, you can do any debt with this car note, mortgages, anything, because you have the law to back you on this. So in Georgia, I think it's called full satisfaction, right? Accord and I think in Georgia it's called accord and satisfaction. And the reason why you can use accord and satisfaction in any debt-related case is because you have the court backing you up. You have the actual code to back you up and you do it administratively. So you look up code, accord and satisfaction. Some states might be a full satisfaction of the claim. And let me tell you how it works. Accord and satisfaction. If you're in a mortgage and you're currently paying for, I would say stay in honor, because with full satisfaction, you can recoup the whole amount of the car plus your payments back. This actual process allows you that, and you can actually win because you have the backing of the court to do it. So it's called accord and satisfaction. Let me see, Georgia, I think it's called.
Full satisfaction.
I think in Georgia it's full satisfaction. Right?
3-311.
Right. UCC 3-311. Commercial code, renegotiable instrument. Enforcement. You have an enforcement clause in here that will actually get you your remedy. This is actually a true remedy in law. So instead of bouncing all around, doing all this other hocus pocus, magical stuff, send them an instrument. First of all, you gotta liquidate. First of all, you gotta have a bona fide dispute. We do a bona fide dispute with debt validation. Tell them, you know what? I saw some after getting this instrument, or actually looking at my contract. I see some flaws in my contract. I don't like the terms of this contract, because contract could be redone at any time. It's a contract, so you can redraw up your contract at any time. You can go and say, I don't like the contract because this is commercial. So you send them a letter, right? A bona fide dispute. But then after the bona fide dispute, then you want to, because this is the whole enforcement. If you read in Georgia, it's under 3-311, OCGA 11-3-311. And in every state, you want to do it in your state, you want to follow your state code. But I know Georgia, so I'm going by Georgia. So when you read what it says, if a person against who a claim is asserted proves that such person in good faith tendered an instrument to the claimant as full satisfaction of the claim, the amount of the claim was unliquidated or subject to a bona fide dispute, and the claimant obtained payment of the instrument, then subsection B, C, and D of this code section shall apply. So when you read subsection B and C, it tells you what happens. Okay? So this is what you do. I know a lot of people are talking about the money orders or whatever. You send a bona fide dispute, right? With your and you want to send it to, and a lot of times too, we're trying to sever these claims, but we're not sending it to the right people. My disputes, I only deal with CEOs. I'm the boss. I deal with bosses. I don't just send a blanket instrument somewhere. I know exactly who I'm sending it to and where. Okay, and I always send it certified mail with a certified return. You want those green receipts, because that's going to be your proof that they received. Okay, so when you do your bona fide claim, you send a affidavit, or you just say a letter. I have a letter too that you can send with your bona fide dispute. Then you go say if you car note, and the car note you pay $350 a month, you're gonna pay that anyway. You go get a money order, right? You write on a money order, and in a conspicuous, because it tells you exactly how to do it, in a conspicuous place on the money order, which usually in the memo section. This is for full satisfaction of the claim. Once they cash it, the claim is satisfied. Okay, then you follow up with the administrative procedure. Say, hey, if they didn't discharge it at that point, because you're going by the law that just says that this claim has been, if they accept the payment, even if they don't accept the payment, it's still they accepted the contract, right? Especially if they don't return it. And even if they return it, if you read the code, every state is different, but if you read it, it tells you once if the claim is discharged, it tells you a claim in section D, a claim is discharged if the person against whom the claim is asserted proves that within a reasonable time before collection of the instrument was initiated, the claimant or an agent of the claimant having direct responsibility with respect to the disputed obligation knew that the instrument was tendered in full satisfaction of the claim. That's your remedy right there. Even with a mortgage, but you're gonna have to follow through. You gotta stay in honor, because the last thing you want to do is have them come steal your car, file a foreclosure on you. So now you have your instrument, which is your money order, full satisfaction on the claim in the memo. Send it to the CEO, CFO, to the address that they're gonna specify. You get a payoff coupon, whatever. You send that with it, with your letter to follow up with your administrative procedure. You do it 3 times. Now you can take them to court. Now you.
Hey, Jessica.
Hey, hold on. Let me speak, love. Let me speak. I agree with you until you said one thing, and I want you to go and read C.
Okay,
for me. Can you read C? And this is what I'm going to disagree with you, and you're going to see why. Because you're giving them a way out.
Which part did you say? Hold on, you say disagree with me. I didn't say anything. I just read from the law. So you didn't
hold
the law?
on.
Okay.
This is what I'm saying. I'm not trying to argue or debate with you or nothing. But
I know. I just want to make sure you said you disagree with me, but I was just reading from the law. So you just disagree with Georgia law? Okay.
No, because when you said that you sent it to the CEO or the CFO. Now, if you go and you read C, it tells you that you only supposed to send it to where they tell you to send the payment to. That's what C says. If you go and
exactly.
read it.
No, you're exactly right. I think what I was saying when I said that, I was talking about the other claims that I was doing. But you're right. I will send it to you. That's why I said you get the actual place to send it. You're actually right.
Correct. And then it's called a disputed obligation. So what I do is I do the same thing that you do, but I name it exactly what it is. And I name it a disputed obligation. And then I will tell them I'm going to send them a money order. And I'll tell them it's going to be for full satisfaction of the claim in good faith, because that's what the code says. And then after that, I wait, and I tell them it's going to be 2 or 3 business days, and you're going to be receiving a payment for full satisfaction of the claim in good faith within 2 to 3 business days of after receiving this notice. And that notice that I call is a notice of disputed obligation according to that code. So then after I send that disputed obligation notice, then I turn around and I send a money order, and I write in the memo line, just like how you said, I say full satisfaction of the claim in good faith. So that way they can't say it was bad faith. And then after I see that they cashed that, then I open a civil action against them, so that way they can't come and repossess the property, or they can't foreclose on the property.
Well, that's the thing. If we don't even want to get to the point of foreclosing on the property, that's why I made sure I say stay in honor, because this is just using your negotiable instrument to discharge the debt. Again, I would not send them anything telling them I'm doing anything. I would just send them because you do have a right to dispute something.
Got time for that.
Not dispute the contract, but it does say if the amount of the claim was unliquidated or subject to a bona fide dispute. At any time, you can pick up your contract and say you see fraud in it, and you can always dispute that claim, right? Then once you do that with a bona fide dispute, as it says in Georgia code. Now, like I said, every state is different. I'm reading Georgia. It says the amount of the claim was unliquidated or subject to a bona fide dispute. So I'm going to do a bona fide dispute, right? And then I'm just going to, when I send the money order, I'm just going to write in the money order as it states inside the law, full satisfaction of a debt. Sent to the designated person, office, or place. That's what it says here in the code. I'm going to follow the code to the T. That's what I'm going to do. If I'm going to mention good faith, I'm only going to put that inside the bona fide dispute letter. But when I send in the money order, I'm just going to send the money order to where it says on the letter. Within a reasonable time before the tender, the claimant sent a conspicuous statement to the person against whom the claim is asserted. That communication concerning disputed debts including an instrument tendered as full satisfaction of the debt, are to be sent to the designated person, office, or place. And the instrument, and then number 2, the instrument or accompanying communication was not received by the designated person, office, place, office or place. So you just read the law and just follow it to the T. There will be no problem, I think.
Yes.
I think that's a good way to go about it.
Jessica, everybody is saying similar things, but what people are doing is you're looking at it wrong. Remember, every time they send you something, the procedures you use with UCC code, and it says you have the right to a counterclaim. The counterclaim is just what you just said. It's under 311. When you sign accepted, return for value, turn that into money order, and say this is and shall be a negotiable instrument. You are, hold on, let me finish. You are going to write on all these little things that you just said. And then you're going to put a cover letter on top of the document they sent to you. I got a satisfaction, release of satisfaction of mortgage. Yeah, everybody's saying the same thing, but what y'all not looking at it in the position that you are. So when you take that code, 311, when you sent the money off, actually when you put acceptance of what they sent to you, and they got all the, and you put money order, it turns it into a money order, then you put it at the bottom. If you go read trust code and from the circumvention law and all that, it says anytime that you write this is and shall be negotiable, it turns that document into an instrument that they have to accept because it's equal exchange. There is no money. So we agreeing that we're using the uniform commercial code like you are doing. So when you write 3311, 3305, 3306, because you are making a tender payment, 12411, then you're gonna write 18 obligations in the United States on it, and then when you put it inside, you're gonna write the names of each one of those codes that you do, and then you're gonna put in brackets the actual UCC numbers, because that means they're not fair. And then once you do that, you turn that document into just what y'all talking about, a satisfaction and a code, and you told them you have the right to recoup it under UCC 3305, and then you told them under UCC 3306 that this is tender. So you did everything on the document, you put the amount in the box, you go down and sign your name the correct way, you turn it over, and you sign the correct way, page it all up, and you send that back with your cover letter, and that will pay that off. And I got a satisfaction in the court from doing some of the things that I have done. I wouldn't tell anybody these things unless I've already got hit in the head sometime, and once sometimes. I've got, in 209, you remember the case in Ohio where we got 14 houses free and clear in federal court? I was on 8 of those houses. So when you use their statutes and code, because I've been in court and they told me, he can't use that. That's barcode business. What you're supposed to use the name and put the code in brackets, because that's fair and all names are yours. So you use the name, that's yours, then you put the code in brackets. Everything you just told her to do is fine, but what she needs to do is whatever they sent her, you must accept it to get rid of it, because once you accept it, you take control of it as a transmitting utility under 9/501B. And so everything you're saying is correct, and we are staying in code. We're not, like when you do that at the court, what you're doing is you're accepting it, you're perfecting it, and then you're giving it back to them under the UCC code. Therefore, you get a counterclaim for the recoupment they took out of your account, and they understand that. So then you send that to their registered agent. Like when y'all send it to the right place, you have to make a copy of everything you do. Look up that, like say if it's Wells Fargo, look up Wells Fargo in your state and go to the Secretary of State, and they will have Wells Fargo's registered agent. After you send this to the place they told you to send it, you make a copy of it, and you take that and you you had registered mail and send it to their registered agent. And once the registered agent he had to tell everybody that proper tender has been received. Because anything that has to be done legally must go to the registered agent. And see, we've been sending it to the wrong. It tells you to send it to the person, but it didn't tell you after that you have to contact the registered agent. You contact the registered agent, and everybody within their system, including Wells Fargo, had to be told that tender has been done.
Hey, Jessica, I got a question for you.
Yes, sir.
What if someone made a payment and someone still stole their property, like car, something like that?
What do you mean made the payment and they stole the car? I don't understand.
Well, someone made the payment, but they still actually came and repossessed the property.
Was it behind?
No, was never behind.
And what was the basis of them stealing it? What was the reason?
They said that they couldn't see the payment, but the payment was in, and they still came repossess the property.
Was it an instrument?
No, it was actually Federal Reserve notes.
I don't know. I don't know how to answer that. That's crazy. I've never seen it in that context where you making the payment, following the contract, and then they come take it. It looks like you should be able to retrieve that if it's not true. Like, I don't know. There must be something else behind it, unless there was something faulty in the instrument where on the initial the initiation of the instrument. I don't know. I mean, you know what I'm saying?
And once they received it, they charged them double the amount to get it back.
Yeah, but why though? My thing would be, I would have to get down to the bottom of why. I wouldn't be able to answer that unless I figured out why they would do that. Because that doesn't make sense. If you're following the contract and you're making payments, there would be no reason unless they found, something faulty in the initial instrument. It was asking for payment, and they didn't receive it. That's the only thing. That's the only way I would see it happening. It could be something else. I'm just not sure because I don't know the full case.
Yes,
Hey, this is Sarah. Hold on, y'all. Hold on. Pause for a second. I have 6 hands up now.
Okay.
So keep in mind that when we exchange and dialogue, that people may be asking questions pertaining to what you're talking about. So I have Betsy, Nicole, Kimberly, Adonai, Ayana, and Kingdom Mind set up. So I'm gonna let Betsy go ahead and ask a question, and then let's see where it goes, and then we're gonna get these questions out the way and continue. I yield.
May I? Okay.
Yeah.
I have a question. I think Big D was speaking on. I had a question basically about my case. I submitted a motion for dismissal, cancel the foreclosure on the 21st. On the 25th, I had a court date for the 25th, a hearing rather, for that motion on the 25th at 9 a.m. I didn't get a chance to present my case until around 11. They proceeded with the sale at 9:20 a.m. So by the time they got to me, it had already gone through. I was not allowed the opportunity to really even speak and even present my case. I got shut down by the judge, magistrate, and I never really got a chance to present. So what I want to find out, I heard Big D say that I need to go and accept. I'm trying to go back. I need to go and go accept that case. Go accept it, or because I haven't received anything in the mail. But it was sold. The property was sold. Was foreclosed on by a third-party entity who I had no contract with.
Judicial code of ethics, and from them going against whatever it is, that's for the judge.
Okay.
And then we got to remember, motions is asking to do things. That's
Okay.
asking for something. We must be notices.
Okay.
So we putting them on notice.
Okay.
And if you still in the property,
Yes, I am.
Dave.
Let Big go.
Dave, they haven't did a confirmation sticker. What she needs to do now, while the property's still in the name, if you can help her, is she needs to actually transfer that to her living trust before they transfer it, because they have to do a confirmation to sell it. And what she needs to do is accept that, and then she has a right of redemption in it. If you can help her with writing a promissory note or a that she gives the court for the amount they say that she owed. And then she gives it to 1099A, and all of that will go away because she will stand on. So what they have done is they gave her a court case on the same day, which they knew they was going to sell it anyway, where she should have been putting a lien on the house and putting it in trust so that no people would have saw that there was a lien on it, so nobody would have bought it. Who bought the house?
Wait. Let's stop right there. And reset real quick. Now, remember when I give you information that you need to do your due diligence, this is educational only. And then also he answered the question, but on the back channel, direct message me. We're gonna answer that question because I think everybody's asking along the same lines. So we're gonna let Nicole go because these people's hands been up at least 30 minutes. Okay. Go ahead, Nicole.
I just wanted to ask, I heard, I believe it was Big D saying earlier about how the law allows you to get 10 times the amount for a summons or for an indictment. I don't have any court cases, foreclosures, anything like that. The only thing that I do have is a jury duty summons that I already, the first time they sent it, I forgot about it, and the second time I didn't have to go. Can I still get a certified copy and accept it and do all of those steps?
Sure, I've never dealt with that, so I don't want to tell you something that I've never done. Like the other stuff, I have actually dealt with out of court and in court. So I have seen some results from some of the things that I'm saying. I have never done anything with a summons for jury duty, but it should be under the same premise because all it is everything is commercial inside of the court. But all of the other stuff that I'm telling you, I have dealt with before, so I have seen failures and successes. Now, everything that I'm telling you, sometimes they back on, they do all that kind of stuff, but you can hold their feet to the fire when you make them disclosure. That's why it's so important. It's in their code, just like the girl was saying. Everything that I'm telling you, there's a code to back it up. They're supposed to be custodial because see, it's called an infant minor. And the infant minor, they said that they're dealing with your securities. And it comes from IRS code, it comes from 26 the tax code, and it comes from 18 and 12, the banking code. So they're telling you that the issuer is the person who signed on the note, and that's who is the true owner of anything. So they put it in the banking thing. So you are the actual true owner of any note that they sent. So that's considered a note. So I've never done that. Like I said, you can try it, but I've never done anything like that. So I'm not sure 100%. But anything that deals with a mortgage, a car note, a bill, or anything like that, I didn't play with. You know, I've gotten cases credited and stuff like that where we didn't even see certain cases, and then you go back and you can see all the cases, and then they all credited. It's just different things that can happen if you do the commerce right and get in the right position. Because everything is following their laws. Most of the time, what we try to do is create our own thing. And they do have a way of telling you how to get rid of everything. So they tell you how to accept. They tell you how to claim your account. They tell you what a counterclaim is. They tell you what tender is. They tell you what satisfaction report is. Everything that we're speaking on, there is something there. Remember, the numbers are theirs. The name of it is yours. Satisfaction and report is yours. UCC 3-311 is there, so always bracket that. Put satisfaction in the court, CF, bracket UCC 3-311 because that's their business. All codes have been incorporated for them to use, and all names of things, just like on your birth certificate, you control the name, but they got the number. That's how we became co-owners of the birth certificate. So you have all the energy inside of the number. So what you do is use their stuff, and then if you go to the IRS with the right code, the IRS, the one thing they are all afraid of, every last one of them is afraid of the IRS. IRS don't care who. They could come get us, or they come get the judge. They don't care. They come get the charter of the court. The IRS doesn't care. All the IRS want is what is owed to them. So if you do it correctly, people will get off your back, because if you do it correctly in court, then the court has to be bonded for everybody that they did for 7 years. And if they're not, then they owe the IRS. So what they'll do is get rid of your case. So if you do everything correctly and follow all the rules, and then you take it, like they're saying, you can take a small claim, you can start a case, you can do whatever, but everything is just following these little codes, just put them in brackets, and then the big thing is making them custodians and taking control of the name, and tell them that you are granting them the use of your name for a future term interest, because now what you did is on that contract. Now you account. So I don't know for sure about that, how to do a jury, because I've never done it, but cases and outside of making counterclaim and sending it to the correct place as far as when you tender payment, like just get satisfactory and all that kind of stuff. And one thing is everybody should do it 1099-A, because that's showing that you have an abandonment, because you was the one who issued, and they are intermediary. They are security intermediaries, and they entitlement, it's all in their code. 31363 definitions and all that stuff. It tells you who you are. It tells you what the document is. It tells you what the court document is. It tells the court responsibility to file tax. It tells you all of that. And all you have to do is follow like they're saying. I paid it. I did it for satisfaction in the court. Here it is. Now, I got a right of recoupment. They didn't give me recoupment. They didn't give it back. I tendered it. So if they refuse your tender, then it's discharged automatically, no matter what. So everything they're saying is true. You just got to make sure you send it to the place like they said, and then make a copy and send it to their registered agent. Every company that is doing business with you in any state has a registered agent, and the registered agent is the trustee of that account.
Gratitude. Thank you very much. Okay,
Thank you.
Next I have Kimberly and then Adonai. So y'all screen may look a certain way and my screen look a different way. So whatever order you may see may not be the order I see. So I apologize for the extensive wait. Normally we're reading and answering questions and reading and answering questions, and the Zoom usually ends at 1:30. So be mindful today, we are going past time, plus we are taking a lot of questions. So with that, I'm gonna yield the floor. Kimberly, ask your question, and then please just answer it so we can get through the people that have their hands up. I yield.
At this point, I yield. I just think I need to have a sidebar conversation, just because I've done some things and I just want to make sure that I'm sealing the deal. So if I can be so kind to get in touch with Big D so that I can just talk to him offline without hogging up the call today.
Okay. Direct message me and I'll send you my email and then I'll get you in contact with him.
Okay, thank you.
Thank you. All right, Adonai, go ahead.
Thank you. I wanted to inquire about how you disagree.
I thought I was next. You said Kimberly. I'm Kimberly. There's two Kimberlys on here. There's a Kimberly something, then there's me.
Okay, well, you were the Kimberly I was talking to, but there's two.
Someone else answered.
Okay. Go ahead, ask your question, and then let them answer, and don't let them extenuate the answer. Let's ask the question and answer.
Okay. Sure. Okay. So I was looking to purchase property from the Strickland Courthouse. They have a foreclosure, you know, in every state, the website and all that. I make money orders that I currently use. I make these and use them. Currently, I buy furniture and different things of that nature with these money orders. I have now for about 5 years. And I'm in the process of looking at a few foreclosures, and where I'm having the issue is, what do I need to do? I know I need to put a claim in, okay? You know, and I have the money order made out and all that. I have all the information related to the case. I'm not sure if I should create a separate case and a sentence, or should I just go in with the case information that's already set up and come in as a third party and do it that way? Any input would kind of help, because that's where I'm kind of stuck at.
Big D or Son of Almighty, do y'all want to answer that question?
I know it's the second one. Son of Almighty answer that one because I've never done that.
Okay.
I've never done it either.
All right, so I'm gonna drop I'm gonna drop the foundation email in the chat, okay, for some of these questions that are being asked. If you will email me the question, and then I will send it to the right person.
Sarah.
Go ahead.
Sarah, because he's not explaining it well. Ask him, is there any way that we can get offline and talk about it? Because he's not explaining it.
That's what we're doing. I'm about to drop my foundation email in there, and then we'll handle that offline.
Yeah, because he's not explaining it well. Okay.
Okay, perfect. Okay, Kimberly, I'm about to direct message. Well, I'm about to drop the email in the chat. Okay, Adonai.
Hi, yes, thank you. I wanted to inquire about how this would apply if you're dealing with an eviction process in which, because at the time you didn't know any better, you haven't responded to anything, but you have court in about 2 weeks. Would this process be able to be utilized even though I've technically already defaulted?
Big D and Son of
Almighty. Talking about the custodian and all that.
Yeah, like when I apply this remedy to that situation.
Yeah, it can be applied.
Could you share some
insight? We gonna get there. I promise. But I want to make sure that we get all the hands down, and then we'll elaborate, because that is possible.
It can go back. It can go back and listen to this recording. You said it was recorded because we already went over that. Like verbatim, step by step.
So I'll redrop the signal link in the chat. Okay, y'all. I'm just trying to make sure that you do have the information you need, either based off what we've already discussed or something else needs to be mentioned. And I'm not trying to say anyone is less important than anyone else, but we do have a lot of hands that keep going up, or people that keep re-asking questions. So I don't want anyone to feel that they have not been addressed, because we got quite a few questions. Usually we don't have this many. So I will, the signal just got dropped in the chat for you, Adonai. That is where I will post the recording, and all the information that you just asked will be provided there. Okay?
Thank you.
You're welcome. Ayana.
Greetings. I have a clarification question just based on what I heard Jessica state and others. Okay, so when she says remain in honor, if you're behind when you are starting your administrative process, are you in dishonor? That's the first question.
Yeah.
Okay.
Yes. Before we elaborate, okay.
Okay, well, if you're already in dishonor, then there's no need of going forward with the process, because if they want fiat debt note and you don't have it, and you sent them other things and they haven't accepted it, then, you know, I don't understand what going through the administrative process is when they've already issued you a default notice while you're in the process of doing so.
Because
Recording satisfaction.
back to honor.
Go ahead, Big D.
You're correcting your status back to honor. Remember,
Absolutely.
remember, everything is an equal exchange. The first thing, this is all I want everybody on this phone to understand. There is no money. They know it. And if we come in correctly using their codes, they will get rid of that. You can go back and correct anything because you are the original person that they created the SSK trust for. So it's on the IRS books somewhere, private and public, zeroed out, paid, but they're only showing one side. They're showing the public. So what you're doing now is bringing the private side of the books up so you can take it to zero. And then what they'll do is zero it out, and then it'll go back to zero, and then you'll come back into honor. Right now, you haven't done, they asked you to do something you haven't done. So now you can apologize and go do what you should have done before.
Gratitude.
Okay, just one last quick question, because just to make sure that I understand, because it's a lot. If I'm on my second notice to them, because they ignored the first, and they already did the notice of default first, they're obviously going to do the foreclosure next before I get to my third notice. So that's where I'm just like confused. Because
if they ever do a foreclosure, you have a right to do an H. The day that you get it, you accept it and do an H8, H9, you can see it. And I guarantee you the case will away because you're the only one to have it right. So they didn't give you the H8 or the H9 at closing. So if they start a foreclosure, go read, I think it's 226 point. I gotta go back.
13, I think.
Yeah, you might be right. And all you have to do is go back and look at that, and it'll tell you the exact procedure. All you have to do is give them that. If they start a foreclosure, that'll stop off the bat because you accepted it, took control, you sent them a custodian letter, and then you say, I wish I knew this way back when, because I used to write so many papers and do so many things and do all that kind of stuff like everybody else, write a lot of stuff, and it would take me so much time to get rid of so much stuff. But it's so simple if you follow their procedures.
Gratitude. Okay, now I got Harry's hand up.
Yeah, there was a question in the chat a little bit ago about when you sent. I think Lucky said when I just gave my testimony. I got a car. I paid. I sent in a promissory note that I had insured through the post office to Capital One. They accepted it. They removed on the website where it's to pay. They zeroed that. There's nothing there. And now I didn't get my title back, and they sent me a letter recently about the old $9,000 or something like that, but they never applied the promissory note, and nor did I go. I insured the check, I insured the note, but I haven't done anything with it yet.
Did you do administrative process default and file a claim against them in court to where you can bring an action against them?
No, I didn't do that. I just basically was going to title. It was good, and then I just report report the check, report the promissory note?
Well, you have to actually do your administrative, actually exhaust your administrative remedies, which that would be your administrative process. You have to file a claim against them, and you bring them in court, and they will actually release the lien, or you go through the DMV to have them release the lien and bring it back to the proper loan, proper one that's in possession, which is you. You remember, you the trustee.
Right.
They actually acting as co-trustees or custodians.
Right. I don't even want the car. Can I just gift the sell it to someone else?
Your name on it.
I mean, okay. Because I just want to get rid of it.
Well, you still have to go through the process in order for to get the title.
Can I get the MC?
I mean, you probably can, but you remember they have a lien against it. So contact the active DMV. You got to release the lien from the DMV.
But if I have the with the master title, it doesn't matter if we have a lien against the title. The MCO is just that sits above it, doesn't it?
If you can get it.
Okay. Appreciate it. Thank you.
Gratitude. Thank you very much. Okay, so I got Danielle with her hand up. Danielle.
Yes. I'm here.
Go ahead.
I have a question. This is about a rescission. I had a loan. I wrote a rescission within the 72 hours. I sent first notice of the rescission. They responded with just sending me a bill and saying when it's due. Wrote the second notice, same letter about the rescission. And